Good evening. It is 6:27 PM on Tuesday, February 6th, 2024, and this regular meeting of the Sandpoint Planning and Zoning Commission is now called to order in council chambers at City Hall, 1123 West Lake Street, Sandpoint, Idaho. For the record, I am Chairman John Hastings presiding. Also present are Commissioners Grant Simmons, Ivan Ramar, Mose Dunkel, Amelia Boyd, and Wayne Benner. Commissioner Scott Torpy is absent. We will now recite the Pledge of Allegiance. If everyone will please stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. First item on the agenda is approval of meeting minutes, and I will entertain a motion to approve the minutes from January 2nd, 2024.
Chairman, announcements.
Oh, sorry. Yes, I missed that. Are there any general announcements from the commissioners?
I do have a couple announcements. The
Okay.
first one is sad news. Sarah has accepted a new position and will be leaving us.
What?
And we are very happy for her, but we are going to greatly miss her.
Can she do that without our approval?
I think we need to vote on that.
Depends on.
Real call.
Congratulations.
Going away party?
Congratulations.
There will.
Oh, good. Yeah, one.
And then just the second is a reminder of the joint meeting with City Council next Tuesday. And that begins at 6 o'clock.
Thank you. Okay. Any other general announcements from commissioners or other staff? If not, we'll proceed with item 5A, the approval of minutes from the January 2nd, 2024 regular meeting.
Would move for the approval of the January 2nd, 2024 Planning and Zoning Commission meeting minutes.
Second.
All in favor?
Aye.
Aye.
Any opposed? I'm abstaining. I was not here, so. Item new business. Next on the agenda is the training session for the commission, and I will now yield the floor to City Planner Amy Tweeten for an introduction of this agenda item.
Thank you, Mr. Chairman. Again, what we like to do is an annual training. Those of you who have been on the commission will have seen some of this information, but we just feel it's important to just, particularly new members, and just remind everyone why we're here and how we move forward. The presentation is going to be found on myself. I'm going to start with the overview of planning and zoning and the roles of the planning commission. So again, planning and zoning is an activity that is enabled by the state. It enables municipalities to regulate land use. And that is governed by the Local Land Use Planning Act of 1975, which is Title 67, Chapter 65 of Idaho Code. The overarching purpose of the act is to promote the public health, safety, and welfare, generally by, and here's this list of things that are the purpose of the act. And these are all things when we're going through the comprehensive plan that we are also addressing, and then that becomes incorporated into our zoning regulations and subdivision. So I won't go through the list, but you see at the top, it's protecting property rights and ensuring adequate public facilities. That ties into what we just had our meeting on, was development impact fees, the economy, the environment, making sure the community is not too congested. So these are all the things that the Land Use Planning Act is created to achieve. Now the Planning and Zoning Commission, what does it do? It has actions that are based on the goals and objectives of the comprehensive plan. It advises city council on land use decisions. There are procedural requirements that need to be followed. There's also times when city council makes requests of the Planning and Zoning Commission to undertake studies or other things. It also provides an additional opportunity for public participation. And your role as the commission, when you're reviewing specific applications or cases, is to always keep that broader community good in mind. And then just to follow the codes as written, and when you feel like there are changes needed, that's when you make recommendations to council for changes of regulations. Why is the Planning and Zoning Commission needed? It reduces the political influence on land use decisions. City councils are elected bodies, you're appointed bodies, so it's just one step removed from politics. It also, again, provides for additional public engagement, both by commissioners as members of the public involved in the process of reviewing land use, as well as you having additional meetings, additional workshops, or public hearings. So there's just that additional review of decisions that have long range effects on the community. And then also just lessening the workload on city council. The statute does allow for city councils to act as planning and zoning commissions. But if they did, they would have a lot more work on their plate, as you all know. So how our local planning and zoning commission operates, it is created by City Code Title II, Chapter 1, which is again enabled by the Local Land Use Planning Act. Our Planning and Zoning Commission is a 7-person body. The member terms are 3 years, and the bylaws are what establish the procedures the commission follows as a body. And we'll talk about those after the training. What is the role of staff? The research, application reviews, and then also serving as that liaison to city council in reporting what the commission is doing. Ensuring that the needed procedural items are taken care of, whether that's noticing meetings, posting hearing notices, drafting minutes, and then providing the technical information in reviewing the applications before you. And then the staff you see here are the ones that are most, that you feel are your staff, which is city attorney, planning staff. And you'll also have the engineer here, but there are other staff members that assist as needed. We've had Heather here with the Arts, Culture, and Historic Preservation Commission. So it's broader city staff than just what normally you see. Again, we know land use can be a contentious issue. So the best advice, and this is Fonda, we'll get into this a little more, is treat the city's liability as your own. You are protected by Idaho Tort Claims Act as long as you are following procedures and code and carrying out your duty as a public official. And this is where the procedural advice of staff and just making sure that is being followed. And then when things get testy, or just don't let things that are discriminatory go unchallenged. And really the world of the Planning and Zoning Commission, the comprehensive plan, you're all well aware. We've been this is our broad vision for the future. The state requires the 17 elements. And this is what's creating the framework for future ordinances, impact fees, capital budgets, master plans. And again, the plan's the vision, and then it's your zoning code that creates the regulations based on the vision, goals, and objectives in that. It regulates land use, building form, and what are the process and procedures you have to go through to achieve a development. And then land divisions are as well. Our zoning code is Title IX of the code, and land division is Title 10. And those are the two codes that we are bringing applications before you that are mostly being reviewed by. So that's kind of the broad overview. As I said, we have discussion of an update to our bylaws after the training. But I will turn it over to Fonda to talk more about the legal aspects of planning.
Magic. Magic does happen once in a while. So thank you. I apologize to those of you that have heard this before, but it is a good refresher. And sometimes we land in conversations based on things that have happened over the last year that are fruitful for tonight. So I am the appointed city attorney. I previously, as most of you know, handled all of your planning and zoning and land use related matters. My colleague Zach Jones is working on that more often now, and I am working more on the general counsel side. However, land use is my strength, so I will continue to be in this arena for as long as needed or forever, because nobody's going to be able to kick me out. All right, so now this doesn't want to change slides. Technology is always the first issue.
I hate it. Not my friend.
Amy, I might have to have you pull it up.
It usually works.
I have it on mine if you want me to.
Yeah, do you want to? Hit share. I don't know why it won't go through, but that's all right.
You want me to pull it up?
Yeah,
Okay.
go ahead.
Let's wait, hang on. Yep. Sorry.
All right.
Okay.
So we talked a little minute ago about who you can go to screen two, slide two. Your staff that works for the planning commission and with the planning commission most regularly, Amy. Christine Coleman is the building official and deputy fire marshal. If you haven't met Christine, she's like a walking encyclopedia. Sarah, who had the honor of being on the screen before I learned tonight that she's not going to be with us any longer, but he's still here today, so we'll leave her on the screen. And then Brandon, if you haven't worked with Brandon, he's the new in-house city engineer. Previously, we had an engineer on contract, but Brandon is in-house and also from Sandpoint, knows Sandpoint very well and extremely bright. And I've been very impressed with Brandon's abilities as we've started working through projects that have been around for a while that still have warts on them or new ones coming in. He's very impressive. So I'm excited for y'all to get to work with him. So we're going to talk tonight about the roles and responsibilities of the Planning and Zoning Commission. And you have both legislative and quasi judicial hearings. We'll talk about the difference of those two types of hearings. We're going to talk about your hearing procedures and your deliberations. We'll talk about outcomes and motions, and then just different land use items that you will encounter over time as you serve on the commission. I put this quote just because I like it. Zoning and planning law lies at the intersection of major legitimate governmental powers and significant individual rights. And those two forces meet right here in front of you. No other commission, committee, or employee or elected official in the city will see the intersection of that more frequently than you will. And as Amy pointed out earlier, even in the Local Land Use Planning Act, your roles and responsibilities the statute starts with protecting individual property rights and then moves into what your obligations are in relationship to developing that planning for development and all different 17 elements that you have to deal with in the comprehensive plan and your evaluation of applications. So you have legislative hearings. Those are matters of general concern. Those will be code amendments. Your comprehensive planning process is legislative. You'll have open-ended comments from the public. They're not necessarily neutral or objecting or individual to me. You don't have an affected person. Anybody in the city can comment. Anybody outside the city can comment. The subject of the hearing must be roughly prepared at the time the notice is published, so it's not as detailed of a requirement when notice is published to the community as to what you'll be talking about. It's an open format. And the closing of the hearing does not affect individual rights. And what that means is when we talk about quasi judicial hearings, you have a very restricted scope of record that you can rely on to make your decision. But the closing of a public hearing on legislative decisions doesn't mean you're like stuck with just the record that was presented to you that night, because there aren't individual rights that are necessarily affected by your decision. So that's what that means. The hearing is closed, but it doesn't mean some individual is going to have some negative or positive effect for them because of their private property rights. So I say all of that just to couch the difference really for you in this hearing process between your legislative and what we'll talk about next, which are your quasi judicial hearings. We'll park here for a minute because quasi judicial hearings are important. It is necessary to get them right. There are a lot of standards of review and standards of approval that you evaluate that will affect individuals. So they do deal with specific rights of individuals, generally private property. Somebody's in front of you asking to do something with their property that they own. Everybody has due process rights in these quasi judicial hearings. So your applicant has due process rights. Your affected parties have due process rights. You're going to hear me emphasize the term affected parties because those that have sat here for a while know that we will get objectioners that will come to these quasi judicial public hearings and they will have a lot to say. And that's great. But the reason we ask for kind of where they reside is so you know how much weight to give to that, because under the statute, the only individuals that can appeal the decision that you've made are affected parties. And affected parties are generally, and I say generally because there are some exceptions, within 300 feet of the proposed project. So we get people across town who want to come and object for a variety of reasons, but if you drill down, they wouldn't have the ability to go ask a judge to force the city to make the decision because they're not an affected party.
Yeah, Fonda. So I guess the spirit would be then that everybody has some standing, but it's weighted more towards specifically in this instance, 300 feet.
Everybody has standing to speak at a public hearing. You have to decide how much weight to give to
Got it.
it. That's your job. And I'm helping you evaluate that by telling you who actually would have standing in a court of law. So everybody has standing to come here, but they wouldn't all
Got it.
necessarily have standing if they wanted to challenge your decision. So notice and opportunity. Does anybody else have any questions on that? Yes,
So is that 300 feet just a number that's been,
it's a statutory number.
okay, So is that because the people in 300 feet are more of a chance of having their property rights changed or affected?
It's because they're directly impacted by whatever the applicant is asking to do. So somewhere along the way, either case law or, I don't think it was the legislature originally, I think it was case law and then was codified. It was determined that that's the footage by which the people are most likely to be affected by a particular land use decision.
Another, on top of that, so property owners or property residents,
Owners.
so we don't usually differentiate that when people come and
And you
speak.
shouldn't, because you don't need to differentiate whether or not they have standing in court. I just need to educate you on that.
Okay,
Because you're gonna have people that don't live within 300 feet, but drive an impacted roadway regularly every day. And you're going to want to give weight, appropriate weight in your decision making to that. So I'm not saying that people outside of the 300 feet shouldn't be heard and what they have to say shouldn't be considered. I'm just helping you give the different levels of weight to what you're hearing from the public.
so when somebody does speak in opposition to whatever hearing is we're hearing, would it be wise for us to say, are you in this area of impact?
Sure.
Because we do hear that frequently from like next door neighbors about, hey, this is,
So if you remember, we used to require every person who spoke during public comment or in relationship to an application to tell us their address. And
Mm.
we stopped doing that because people
Mm.
were threatened. In this
Mhm.
culture of conflict that we have, it became unsafe to tell the public where you reside. And that was the result of the COVID era, where now everything is also on video and it lives out in the universe forever. And so it became unsafe to force them to tell you their exact residence. So we just ask, do you live within the city limits or not? So that is fair, but in relationship to a quasi judicial hearing and you trying to determine how much weight to give particular comment, we can ask for a little more detail if you think you need it.
so that's something we could ask and we're
I-
justified.
Well, I'm gonna have a slide later that says public comment is not a time for debate or questions, so you have to balance that.
This does mostly like conditional use permits and stuff, right? I mean, we
Um,
typically, I mean,
What,
I mean, people usually make it known if they're within this area, I think.
or they'll say, I drive this road every
Yeah,
day on
yeah,
my way to work, or I use this park all the time. I mean, they're usually pretty good about telling you why they're speaking, because they think it's going to impact them in some way.
And generally, because we notice the people within 300 feet, if you get written comment, they generally are within that.
Hmm.
If they're from outside that, they generally would have seen the notice in the paper or the article in the paper.
okay.
But very infrequently do we get written comment from people that aren't in that affected area.
And the size of the project doesn't impact, it's the 300 feet, which is
That's correct.
Yeah.
That's correct.
Not a very big area.
No, it's
I
not.
mean,
I mean, when you think the size of a large project like University
Yeah,
Park, that
exactly.
impacts everybody, obviously, but only those people within 300 feet would have legal standing.
Right, right. So notice an opportunity to be heard. That's why there are all of the noticing requirements in code that your staff does a tremendous job of meeting those all of the time. A quasi judicial hearing requires a transcribable verbatim record. So I want to be really clear. You guys do a great job, but there are other committees and commissions that do not. It's important to ask your commissioner for permission to speak. It's important not to speak over top of each other. The reason it's important to ask your chairman for permission to speak is so that he or she can address you by name. As you can imagine, if we have to take a voluminous public hearing audio and send it out to a court reporter to be certified because we have somebody file a petition for judicial review, those court reporters have no idea who you are and they have no idea who's speaking if we don't mirror that with audio, which we don't or can't always do, or you're not being addressed by name. So because we have a statutory requirement to have a transcribable verbatim record, it's really important to speak one at a time and to be addressed by your chairman so that he can acknowledge you by name and we can have a clean record. And judges get really, really cranky if their transcribed record is not really clear. So
But tonight is just discussion.
tonight is just discussion. Yes, this would not have a transcribable verbatim record. It's a good place to practice. You would play how you practice.
I
Yes.
do have a question. Has it ever come up, you know, when we limit comments to 3 minutes, has it ever come up that we're in some way infringing upon someone's right to tell us everything they want to tell us if we tell them they've only got 3 minutes?
No, it
Okay.
has not. You have a right to have your rules of decorum and to provide a time limit. So you have a right to do that.
Okay.
I shouldn't say no, it hasn't come up. We've had people who have loaned their time,
Yes,
given their
correct.
time to others.
Yeah.
As you know, we get more objections to the limited time frame in the public comment arena than we do in the quasi judicial hearing.
Okay.
All comments need to come in during the hearing, no ex parte communication. We're going to get to ex parte specifically in a little bit. And primary topics include land use. I skipped one. I want to stop for a minute on comments should come in during the hearing. So I've had situations where we've had a public hearing. We close the public hearing, so your record is now closed. That's all the information you can rely on to deliberate. And commissioners or council members start saying, well, I drive that road and I don't think that, you know, and I think the traffic is too bad, or I have this experience here, or I have this opinion about that, or I didn't see any of this information come in the record. Can staff go get me, for instance, the traffic impact analysis? Well, the record doesn't include any of that yet. So if you start talking about things in deliberations that haven't been presented to you, what my mind is doing is, okay, now are we teetering on needing to reopen this public hearing because the applicant's due process rights have been violated by his or her inability to respond to this new information that's coming in. So if you see me start twitching or Zach start twitching, or I have been known to look at Mose and go,
Yeah.
stop talking.
That sounds on brand.
That sounds about right.
Yeah.
It's not because you
does.
don't have things, you don't have something important to say, and it's not because your information isn't valid. It's because we have a closed record and we need to protect that closed record. So if you're prepared when you come in and you think you want to ask some of these questions or get some of this information on the record, do it while the applicant's up here and ask them questions. Ask questions to staff while the public hearing is still open. You can get that information in that's important to you, just not during deliberations. So nothing should be new during deliberations. That should just be all information that you've already heard or you've seen in your packet. Okay, fair enough?
And whether it's public or staff or commissioners, if we wanted to bring in new information, is it acceptable to say we want to reopen the public hearing at this time to bring in new information?
So there's a process for that. And yes, you can. You need to complete your deliberations on the pending question before you.
Okay.
And the completion of those deliberations could be, I make a motion to remand this back to staff to provide us with,
More
X.
information. Yeah.
and then we will we'll notice it for public hearing. That information will come in. The applicant and the public will have an opportunity to respond, and then you'll deliberate again.
Okay.
So yes, there is a process for doing that. What you can't do, and this, I just had this situation, and now we have a mess to clean up, not here. What you can't do is table your deliberations pending the receipt of new information,
Gotcha.
and then not give your applicant and your public or your affected parties an opportunity to respond to what only you're going to receive.
Gotcha.
So,
So that could all be in the same evening?
yeah, not the second public hearing, no.
Okay, so if we, hey, we think we're done, we close the hearing, is done for that day.
So you close the hearing and then you start deliberating, and all of a sudden, one of you realizes you want additional information. you would ask your other commissioners, I'm thinking about making a motion to remand this back to staff for this additional information, and then we would likely tell you at that time that's going to require, you to reopen the public hearing, so we'll reopen it at the next meeting. If we have time to notice, it all depends.
And that would be a fairly large event.
It's just more time.
Yeah. So the more time thing, to me personally, my opinion is it's like, that's a big deal. So there's no option, like if we just overlook something, there's no option to like make that right in the same evening, even since everybody is here and we're just talking about like maybe 10 minutes of difference.
If the information that you need is not in the record, you can't use it to make a decision.
Okay.
So if you think you need it to make a decision and you don't have it, we have to open the public hearing and get that information in the record.
And that second meeting probably can't happen because it wasn't noticed.
That's correct. Well, yeah, it would not, the applicant would not have had an opportunity to see it in any sort of a staff review manner to have time to respond to it.
Okay, I understand.
sense?
Yeah, yeah,
You've had a few of those.
yeah.
Go ahead, Amy.
Go 1 second, Commissioner Bennett.
Go ahead, sorry.
Can it be open to ask the applicant for clarification on an item that they may have
After
said?
the hearing is closed?
Yeah,
No.
open it back up. Okay.
No. No, so if you really think you need, that the applicant's rebuttal time is when you need to get all the last little tidbits of information from them that you think you need.
Okay.
And, you're just cursed with a trial lawyer up here that is stuck with what is evidence and what's in and what's not in. And that's just, a hearing has a purpose. And the purpose of the hearing is to get all of the information in and for all of the parties to be able to comment so that you can make an informed decision. So.
Don't close the hearing unless we're sure.
Mhm. And if you've had no public comment, so sometimes your applicant will say, there's been no public comment, I don't wish to rebut. However, you may have thought of additional questions and we can ask them to please come take the podium so they can field some additional questions.
Yeah, we've done that.
Mm-hmm.
All right, the order of your public hearing, you all know this very well. You get an explanation of the hearing procedures by the chairman. You get a staff presentation, an applicant presentation, testimony from all the people supporting, neutral, opposed, rebuttal by the applicant, and then close the hearing and initiate deliberations. So before you close, and Mr. Chairman, it's probably a good idea if it's a hearing that's had a lot of information, to look at your commissioners and say, are you all okay for me to close the hearing now? We put it in your script to just close it, but
Right.
it's okay to ask. And then you're gonna develop a reasoned decision and then you'll adopt a written decision at a later meeting. So you make your decision that night and then Amy puts together a written decision. They don't come back and adopt them here though. You just send out the
No.
notice. Other cities, they come back and adopt them. All right, moving on. Public hearing deliberation best practices. So before I go through this list, I want to remind you that the definition of deliberation by law does not mean just the conversations that you have at the dais amongst yourselves to come to a decision. Deliberation means any conversation you've had with anyone that helps you or assists you in any manner in making a decision. So this is why it becomes very important. I have super sneaky commissioners who will say, but I'm only talking to one other commissioner, so it's not a violation of open meeting. Well, there aren't 4 of us, so we don't have a quorum, so we can all 3 talk about it. Not correct. If you in any way have any conversations with each other, even if you don't have a quorum, in relationship to an application of any kind that is entitled to a public hearing, a quasi-judicial public hearing, and that conversation aids you in making your decision, you have deliberated. and deliberations cannot happen outside of an open meeting. And this is, you are under a microscope here. And if Melissa Ward were here, I'm sure she would tell you the volume of public records requests that every governmental entity is getting right now. And it is, give me every text message and email communication and evidence of a phone call between Commissioner Boyd and Commissioner Benner from this point to this point. Because somewhere, somebody thinks that the two of you had a conversation outside of the dice. I'm just not picking on you. This isn't real. I'm just.
We do all the time, all the time.
But somebody somewhere thinks that
Spend the
you
weekend
had a
with you, too.
conversation outside of deliberations and they're trying to drill down into that. So just don't do it. You get a complete staff review. You will have a very well-run public hearing process. You were appointed because you are intelligent and perfectly capable of making these decisions. And it is not worth dumping your private cell phone into my lap or the city's database when you can make these decisions without that extra assistance. You are allowed by law, if you need to go to a site, you can go drive a site and you can use that information in your deliberations. I drove out there today. Amelia has done that before. I drove out there today. I looked at this for myself. I just needed to see it. You can do that, but you can't talk to each other. And then we'll get into in a little bit ex parte communications. So, yes,
You want last bullet point?
no, keep that one.
Oh,
I'll
Just-
say this, we bump into each other all the time publicly and we're very good about it.
That's awesome.
Yeah.
I love that.
Yeah,
And,
we know it comes up.
commissioners aren't as hotly targeted as council
I would
members.
imagine,
mean,
yeah,
you know, But there are things that will come to before you where you are the final decision maker, and those can get a little contentious, so.
A s-
so go
A
ahead.
small point I'll comment on, and that is just because this has come up before, if you're taking notes on any of this stuff and you take it with you, it's yours if you take it with you. If you leave it behind, it's public record.
And keep it at your house and
Yes.
don't ever talk about it.
Yeah.
Shred it. Have a best practice of when it's over, just shred it or burn it. We had a city administrator not that long ago who was in a deposition seat and, it was not the city administrator here, so I want to be clear. She made mention while being deposed that she regularly keeps notes in these notebooks. And I do the same thing, but mine are all privileged. And those notes
Mm.
that she keeps that are her own private thoughts on everything related to her work became public record because she mentioned in a deposition that in the course of her work, she keeps these notebooks. And so it's really important, not that we want any of you to be in a deposition seat ever, but we also don't want somebody to make a public records request for all of your private notes. And there is not an exemption. Well, there's a slim exemption under the Public Records Act to prevent those from being produced, but you've seen what's been happening in the public, you know. So public hearing deliberation best practices, again, I said before, ask the chairperson when you wish to speak. All commissioners are given an opportunity to speak. Your chairperson has always been very good about making sure everybody has an opportunity to speak their mind. Come prepared to speak. Members of the public and the applicant address the commission, not the applicant or the staff. So the public addresses you and addresses you only. We don't invite an environment where they have an opportunity to speak to the applicant or staff ever. If an answer is warranted, the chairperson will ask staff to respond. If a person from the public asks a question that warrants an answer, you can look at me and say, do we have to answer that? Should we answer that? Should we not? 9 times out of 10, it's harmless. We should just answer the question, but there have been situations that do not warrant a response. And then the commission should go through each decision point and try to reach consensus on whether or not the point is met. So Amy will always put up for you your standards of approval, and you should go through those standards of approval and make sure that the facts that you have been presented with, that you have enough facts and that you can make a decision on each of those points. Yes.
If somebody comes up and is speaking, they ask a question and they're really wanting a response, we're not required and you're not required to answer them, right?
So it is not a question and answer period. There will sometimes be, like I had one recently where the lady who came up to make comment actually wanted to know from the applicant if he was going to be replacing the fence he had torn down. And he just politely said, talk to me after, I can take care of that for you. So there's opportunities to facilitate conversation. What we don't want to do is create an environment where the public thinks they're entitled to this being a debate, because it's not. So the role of P and Z and council is to listen to the testimony, read your staff reports, reach out to staff with questions. So you new people might not know, when you get a comprehensive staff review or staff report, you can contact Amy or myself with any questions that you have on that staff report ahead of time. It's not doing government in secret. And that's what I've heard in the past. It's that you want to make sure when you ask the question from the dais in front of the public, that we are prepared to answer you. We give the public a better process if you ask good questions and we can give you detailed answers. If we don't know ahead of time what your questions are, then you will catch us off guard, and it's not a best presentation to the public, nor does it give them the best product if we can't answer those questions. It doesn't mean don't ask them later, because that's what we've been accused of is, well, you ask for those questions ahead of time so that then the public never knows what the commission's questions were. Absolutely not. You're going to ask them. We just want to be able to answer them. You're going to make, second, debate, vote on motions. That's your job. You have been appointed to make decisions. You've been appointed to cast a vote. You don't want to do anything to remove yourself from being able to cast a vote. Again, we'll get into bias and conflict of interest in a few minutes, but you want to make sure that you maintain your ability to vote. That's why you're in the seat. And then you guys don't review written decisions, so you can ignore that. What other cities do is you'll make a decision from the dais. Their staff will write a written decision consistent with what you said, and then that written decision comes back to you for approval. That is not a process Sandpoint has adopted. But I use this PowerPoint everywhere, so.
Although the minutes are approved and those generally have your motions in them, so.
They do. They just don't have all the detail of everybody's questions and your deliberations and how you applied the facts to the standards of approval.
If you are living within 300 feet of a proposed project, should you recuse yourself from that decision or not necessarily?
Not necessarily. If you are a truly affected person, you should identify that as a possible conflict of interest. And then I would ask you a series of questions on the record that you can answer to determine whether or not you have the ability to be neutral and unbiased. It's not a hard process. And most electeds or appointeds will come to me ahead of time and say, I might need to recuse myself, and we'll walk through that ahead of time. And if you are within the 300 feet, then you just make a record of, I am within the 300 feet. I am an affected person. I have consulted with legal counsel. I can be neutral and unbiased, and I will not be recusing myself. But we make a record. The worst thing you can do is sit in silence. And I'm not going to know if all of you live within 300 feet or you're an affected person. So if you have a little stirring inside yourself that maybe you need to figure out whether or not you should recuse yourself, just talk to me ahead of time.
So outside of hearings and meetings, we can request of city staff information and the like, right?
It depends.
Relative to, yeah, because I'm wondering where the line is in that. Because it feels like you could get a weirdo on up here who just does nothing but make requests for
Well,
research and
right.
information, and you know what I mean?
So here's the rule of thumb is none of the staff works for any of you individually. They work for all of you collectively. So if you are asking for information to help you make a decision on a particular application that you've received a staff report on, absolutely, you should ask staff those questions individually, and you don't need to consult with your other commissioners. But if you're out asking for studies on this and information on that, and I mean, we have had electeds and appointeds who have abused
Got it.
staff, and staff is fully empowered with reporting that to the city administrator or the mayor. And we have had electeds and appointeds who have lost their privilege.
But it's at
Communicate
staff's
with-
discretion, I guess is the point.
They will say, they know when it
Yeah.
crosses a line. They
Okay.
know. But yes.
Adding on to that, let's say me or Grant or anybody asks a question and now it's like, well, that's a good question. Will the rest of us have is there any opportunity that the rest of us would hear that question before the hearing? Like
So if one of you
through-
asked a
through
really good
staff.
question and Amy thinks maybe the rest of you need the answer, yes, we have had that situation where she has then sent out an email or I have sent out an email that says, hey, this question was asked. Here's the answer. It might be beneficial to all of you.
All right.
So the role of the applicant, when they come in for a hearing, is to present a summary of their application and then the support for their request. We have had some applicants who kind of missed the mark a little bit on that, but that's okay. That's their
Just a
job. is-
few.
Yeah, they know, I mean, they've been given all the same information you have as far as they've seen the staff review, they know the standards of approval, they know the evidence they need to give to you, they just sometimes miss the mark. And then they need to answer questions from you, and then they need to rebut the testimony from their opponents of the application, or rebut any questions you've asked that they feel they need to clarify. So that's their job. You have a right in rebuttal to ask the applicant, even if they choose not to rebut, is there any other information you'd wish for us to consider right now? Can you think of anything else? Kind of that catch-all question to prompt them to maybe give some more detailed information. Go ahead. And then we talked about this a little. So the role of the citizens is to testify to the positive or negative impacts of the proposal, informing P and Z or council about the characteristics of the site, suggesting acceptable ones that meet city standards, alternatives, or ways to mitigate the negative impacts of the proposal. This is very detailed, and this comes right out of every governmental manual that you will find. And I would say our citizens miss the mark more often than our applicants do, because they really need to speak to the positive and negative impacts and ways to mitigate it. We don't often get the suggestions on ways to mitigate. And I know that that can be hard. Sometimes what we're talking about is very technical. Traffic is a great one. You will have trip generation that is created, and it may or may not trigger, it won't trigger a traffic impact analysis, but you'll have people come in screaming and yelling that this project needs a traffic impact analysis, but it's not triggered by code because the trip gen doesn't support it, and they just don't understand how it works in these four walls, and we're just patient and give them mercy and let them speak their piece. Or they don't understand the importance of the expert evidence that a traffic impact analysis is, and they aren't engineers, and they want to direct you how to reroute traffic contrary to what you've been given from your own expert. And we will, if we ever have to, talk about the importance of relying on your experts and not deviating from what your experts are recommending to you. That is, if you deviate from what your experts are telling you because someone's impassioned about how they think it should work, it's called arbitrary and capricious decision-making. That is like step number one for a judge to say, I really, commission, want to give you deference, because the court will. They'll always give deference to the governmental entity. I really want to give you deference, but you went out of bounds here by not listening to your own expert. So role of the citizens, and you guys can help educate citizens. You will have people who are like, we want to come speak, but we're never listened to. Well, you can guide them. Come and present comment on the negative and positive impacts, and keep it really directed at how those can be mitigated. Not just at, I don't want this project. And I say that for a purpose, because you have projects that come before you that Mose hates this term. I'll say it. They're matter of right applications. You don't have wiggle room to deny them. It is a preliminary plat on residential property that they have met every code requirement.
Yeah, what are you
It's going to increase traffic. Yep, but it's a matter of right application. You have services available. You're not in a moratorium for any reason. They've developed the site consistent with code. They're not asking for any code deviations, and they're not asking for a zone change. And you can put a really keen eye on it, make sure staff hasn't missed anything in relationship to the code requirements, but There are applications that are a matter of right, and the public doesn't understand that. They really don't. And so you can help educate as people talk to you, because they will, and they do. So,
Would that, along those lines, a future topic, building heights? That's one that comes up really frequently. And when I'm asked about it, I typically have to say that same thing of, in this area, this type of use, parking, et cetera, there's a right to build this height. So why wouldn't a developer, if you owned it, what would you do, And usually the response is like, yeah, it's still not right though,
and you will, if you see that topic come up in the future or anything else like that, a code change, because that's going to require a code change, those are legislative decisions. So those are decisions that'll come before you. It'll come to you as a recommendation, or you'll be asked to make a recommendation to council. But those are topics you can talk to the public about. So you can have conversations, you can listen to them. I wouldn't share what your thoughts are, because you don't want to be accused of being biased ahead of time, but you can gather information and talk to the public about those legislative decisions. So that's right in line with gathering information for decisions. So your staff report is prepared before a hearing. You should review it and understand it as best you can. Application must solicit facts. So the application that you look at, it's always in your packet. That's where your facts come from the applicant. You can incorporate information from other agencies before scheduling a hearing if you think we need that, if you think staff hasn't given you enough information. Sometimes we'll see that around perceived wetlands or waterways, or people just want more information and they may not understand what the municipality has jurisdiction over and what it doesn't. And we oftentimes have a lot of education to do in those arenas around who has jurisdiction over what. So then you can add comments to the application and staff report. I mean, that's just if you have any. You don't have to go into all of this in detail. You're going to organize your information in your head. You're going to have advocacy by the applicant. You want to tie down your objective facts, look through what you've heard and what you've seen and figure out what is undisputed, tie those down. Again, we talked about don't add supplemental materials or information after the staff report or deadline, and then you should have your questions ready. Do your homework. I'll say that a million times. You can skip the next one. Go to determinations. Skip that one too. So after a quasi-judicial hearing, you're gonna explain the criteria and standards considered relevant by the commission and state the facts relied upon. So you should walk through each standard of approval and talk about the facts that either support or don't support approving that standard of approval, and explain your justification. I say this to all my commissions and councils. At the end of the day, I don't care. I do not have a dog in the fight of what your decision is. My job is never to drive you towards a decision. That's why you don't hear your staff making a recommendation. It's your job to make a decision. My only ask is, and that's why we do this training, make it defensible. I need to be able to stand in court and defend the decision you've made if somebody challenges it. So make sure that you really, thought your way through a defensible decision, whether it's yes or no.
And a quick comment on that. I know that sometimes it gets intimidating when the motions and appear to be quite lengthy. When we're basing it upon fact, and if we have that list of facts in front of us, we don't need to go through them all.
That's correct.
We
You
can say, I'm doing it based on this. As long as we base it on something, we don't have to base it on everything. So you don't got to go through.
Unless you
every
have
one.
a CUP where you have to meet all of the elements, something like that.
That
But
would be
yes,
different, yeah.
yes. And Amy does a really good job, and Sarah, of really pulling out of your deliberations for the minutes, like the facts that you have relied upon. You'll have a hodgepodge of conversation, and they'll pull that stuff out of there to take the pressure off of you of having to feel like a judge. I mean, you are a
But
judge.
in the
but-
motion, when we make a motion, you usually have to say at least one fact. that we were using to make this
Yes.
motion.
Yes, you do.
Yeah.
Or you have to say, all of the facts presented here tonight and as viewed in the staff report, meet all of the standards of approval, something along
Something,
those lines.
yeah.
Yes. You can't just say, I make a motion to approve X.
Yep.
It's, I make a motion to approve X because. But you get, draft
Yeah.
motion.
We do, yeah.
You can,
Excellent.
yeah, next slide. So how to reach a decision, discuss it first, don't rush to judgment, every member participates. We've been through this, identify the applicable standards, and then the justification for your decision has to be based on the criteria and standards. Idaho Code 676519, I share this with you because the emboldened section of this is really important. So this is where the code says you have to give your reasons for approval or denial and the actions, if any, that the applicant could take to obtain approval. So if you're going to deny an application for any reason, you have to be able to articulate what that applicant could do to obtain approval. If you don't believe there is anything the applicant could do to obtain approval, you have to articulate on the record why. So that's also a lot of the public doesn't understand that this is in Idaho code and is required of you and of council. Yes, you have those big old like eyes of,
Ooh.
you just told me something I didn't want to hear.
Something that I felt like I wasn't aware of.
Oh,
What? I am having a flashback to a year ago, nearly today,
I have a bad.
when she
I'm
said
afraid.
that and you had that reaction.
see, now I know I would say every year.
So. These,
And we had a discussion about it.
yeah, well, we can keep discussing. I mean, practice makes perfect, right?
See, we gotta keep practicing.
Love you.
Some things I just tune out.
You didn't like it then and you don't like it now.
I think that's a slippery slope. Maybe I said that last year. Cause if we put those forward, they gotta be a fact or a law or, you know, something that's, are we telling the applicant, if you do this, then it's gonna pass?
So it's gonna look more like, it's not gonna be a technical denial, because remember, they're not getting to you if there's room for you to technically deny it, because they've worked with staff for so long. And if there's room for you to technically deny an application, it's staff's gonna be standing up here saying, they don't meet our code here, here, and here. And you're like, ding, 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 silver platter. But it's more along the lines of, you know how we get in that gray area
Yeah.
of the
Are you-
comprehensive plan?
Are you sure you got drainage right? I
Mm.
mean, that seems to be a thing that comes up a lot.
Right, are you,
Right.
or you're gonna be saying, I wanna deny this at this time. I want the applicant to go back and work with staff on their stormwater plan. I'm not convinced that that stormwater plan or their idea for it, because by the time, when it gets to you, it's not in detail, right? It's just kind of a cursory idea. I want more detail and making sure that's gonna work, something like that. Does that make sense?
Yeah, I'm thinking in regard to fairgrounds.
Oh, we can't talk about specific projects.
So something north of town where it was a denial hypothetically, and I guess it didn't meet, so it didn't meet what we felt like there was too many issues with it. And,
And but I think it was, those were technical issues.
but, okay, so,
So there are
Mm.
applicants who are
Mm.
stubborn or
Mm.
arrogant, quite
Yeah.
frankly, who will literally tell Amy, I don't care if it's a violation of code, I want to take it in front of the commission. And she says, okay, well, you understand, I'm going to put in my staff report that there are parts of your application that are in violation of code. And they think that they can come in here and persuade you. And some of them have been successful in convincing you that Amy should have interpreted it differently, or that she's reading the code wrong, or that they should just be able to get away with it. And so those are the cases where you really need to talk with your staff ahead of time. If you have a staff report that's telling you that there's an application coming to you that has code violation, that is not compliant with code, that's a red flag. That's a red flag for you.
Or Fonda, could another example be if there's an administrative decision appealed to the commission?
Yes.
So we make we deny a building permit application, site plan review because something was not,
Up to code.
Compliant with code.
yeah, compliant. And they could appeal our determination to you. Because they don't believe that it was interpreted correctly.
And if they didn't like our determination, they could appeal it again to council, correct?
Yes.
Yeah.
And that has happened.
I know.
Yes.
Because I got this, I have to ask a lot of questions. No, one would be going, I mean, if I'm sitting at a meeting here, and I'm gonna keep quiet for the first couple, because I don't know what I'm doing, but anyway, no, I'm kidding, but if I see a thing just running amok, at least in my vision, running amok, can I ask Mr. Chairman and say I make a motion that this be tabled until the next meeting or something to that effect? If
You can table it and we have to table it for a date certain. And usually there needs to be a reason coupling why you're tabling it, more than just, I mean, you would articulate why you're unable to make a decision that night.
They wore the wrong jersey in here.
So-
Fair enough, fair enough.
So if one, we still have to second and vote on tabling.
You
right?
do, that's
So,
correct.
so if one of us is having an issue, then that's not necessarily all of us agreeing to.
Right,
I think, are you thinking about, like if just the decorum is just like out of control?
your
almost?
chairman's gonna.
I don't think you're.
Yeah, I mean, if John was here, I mean,
Yeah.
but I'm just saying, if I'm just looking at this and in my head, I'm going, I think that there's an issue here that we're missing. I can't exactly say what it is, but you're saying I do have to say something that,
Well, if you said, I think there's something here that we're missing and I need more time to review this packet and maybe listen to the audio from this meeting, you certainly can do that.
oh, okay.
Yeah. Because sometimes that's it. You get information at you like a fire hose. And there are people who are processors, you know, you need to think about, you need to take now that staff review side by side with what you heard in public comment and or re-listen to the meeting and be able to have a more robust deliberation. And if that's the case, you absolutely say that, just like, I need time to process this. I'm not prepared to make a decision tonight. I make a motion to table our deliberation. Absolutely do that.
Thanks.
But one point here is in the highlighted words, it says the applicant could take to obtain approval. It doesn't say would or will obtain approval. So,
You have to tell them what they can do, whether or not they do it is on them.
and then if they do that, there's still another hearing. And that doesn't necessarily mean it's gonna pass just because they changed the one thing or whatever we may have said.
It could.
Could, but no guarantees, right?
No guarantees.
No guarantees.
Okay, I'm okay with this now.
It's Idaho code.
You got it?
I can't change it.
No, well, I'm just trying to understand. Like, to me, at first, it sounded like, oh, well, if you change the color to blue, then yeah, it's gonna fly. So they come back around and change it to blue and we have to approve it?
Yes, if you say it that specifically, if you change the color to blue, it will be
If we are
approved.
that specific.
Yes,
But if we say, if these things were different, you could obtain approval. Could is not a for sure, right? Is
Yes.
could one of those words? It's like,
Ambiguous.
it's not gonna lock us into, a decision in the future.
I would hope we'd be a little more specific in our language, I guess is what I'd say.
this is not an area where, again, you're going to be in a position to be telling an applicant what they need to do from a technical perspective. This is gonna be, I'll just make something up, a PUD comes in for preliminary approval and you look at it and say, I just don't think that there's enough open space here for us to even consider this. Or I don't think that the code deviations, I think the code deviations are too great for what we're seeing as the community benefit. I'm not seeing a fair trade-off here. If you went back and reoriented this to provide us with more open space, or you move this density over here and, you know, you move your densities around for a more inviting neighborhood, I think you might have a better chance at approval. That's more what this is geared towards.
Mhm.
That help?
Mhm.
Skip the written decision. Reconsideration is next, so everybody has a right to seek reconsideration of any final decision. So you won't see anything on reconsideration other than, are variances still here? CUP.
Variances and CUPs are here.
CUPs. So you're the final decision makers on variances and CUPs. So you could see a request for reconsideration if you denied one of those, or a request for reconsideration if by an affected party, if you approved one and they don't like it. So due process considerations, quasi judicial hearings, I touched on this a little bit before. They're grounded in considerations of due process and the applicant's right to have a fair and impartial hearing. That's why they must be free from conflicts of interest, bias, and ex parte communication. And so next is conflicts of interest. You won't see this very often, but maybe, but it's, if you are to receive any pecuniary or economic interest from the application that's in front of you, you have a conflict of interest. And then at the very bottom, it says no member of a governing board or a planning and zoning commission with a conflict of interest shall participate in any aspect of the decision-making process concerning a matter involving the conflict of interest. So.
Should they actually remove it? Is it more than just being silent, or should they actually remove
You have
themselves?
you have to declare your conflict of interest. You have to declare why you have a conflict of interest, and you have to leave the dais. and go
Leave,
sit
that's what I
down.
was gonna ask, leave the dais, yeah.
And the reason for that is because you can't sit up there and snort and grunt and make facial expressions and pound the table.
Body
and
language.
Impact your fellow commissioners' decision-making.
But you're a member of the public at that point though, right? So you can still,
You are not a member of the public.
oh, you're
You are
not.
a
So you don't
recused
have
commissioner
standing,
sitting
you
in
don't
the
have,
back of the room
oh, interesting. So
silently.
you don't even have standing as a public citizen at that point. Oh, interesting.
You
Oh,
can make faces back there.
I'll sit you outside. if you're gonna
Yeah, interesting.
Yeah, you don't get to take your commissioner hat off in that moment.
Oh, okay.
And likewise, if any of you newly electeds have been very vocal in the past about any projects that are likely to come before you or that do come before you in the future, we'll have a conversation about what public comment you have provided or participated in, and you might have to recuse yourselves. We have had council members who have been activists against certain projects and then get elected, and I have to give them the bad news that they do not get to participate in any decision related to that project. Yes, sir.
Really?
Yeah.
Even very recently,
Um,
like this month, like last month?
Talk about specifics.
Well, it's not, it doesn't have anything to do with us.
Yeah, that's right.
Like,
That's,
no,
that-
but I don't know if the projects come forward. So anyways, we don't have to, just know that
afterwards.
if
That's
you've
interesting. I
been
didn't-
vocal,
Yep.
I know which one he's talking about.
if you
We all
posted
do.
on social media, if you've been quoted in the newspaper, if you have spoken out in opposition to any project that requires a quasi judicial hearing, you will likely have to recuse yourself. And then we get through that season of time and then your nose is clean and all is good. So, bias,
kind of on the same line, so is it something is not quasi judicial, but it's going to the council after us. Is it appropriate for us to ever come and provide public testimony at a council meeting?
no, you should not if you sat as a decision maker as a
Gotcha.
council.
Thank you.
No, you shall not.
Good to know.
What if,
They have the opportunity to watch, right? To
Correct.
watch all of your deliberations and hear all of what every one of you had to say. And so that is your time to provide comment to your council because they have all of that available to them.
Got it.
Gotcha.
What if we are ever an applicant?
That can happen.
So we could present an
You
application?
can Go through the process just like any other
Have to
citizen, you
recuse
just,
yourself from the decision.
you'll stand over here.
Yeah,
instead of
But
over
are you a
there.
member of the public in that?
yeah, that's my,
Well, you're
Are
the
you a
applicant.
member of the
You're
public
You're the
in that?
applicant.
Not a member of the public. You're the
Oh,
applicant.
okay, so
You're the
that's
app-
your standing as applicant.
Yep,
That makes
yep.
sense. Yep, okay.
so you take the commissioner hat off.
And all the rest of us still have to recuse ourselves.
Nice,
So there's nobody up here then.
nice.
Why not? Let's find a way to do that.
If we were real deviant, we would talk about this with everybody for like a year.
I want to point out on bias quickly, so every applicant is entitled to an unbiased decision maker. And Bonner County gave us our famous case to help us understand what bias is, because they're very good at that. And so pre-hearing statements by a decision maker are fatal to the validity of the zoning determination if the statements show that the decision maker, A, has made up his or her mind regarding the facts and will not listen to the evidence with an open mind, or B, will not apply the existing law, or C, has already made up his or her mind regarding the outcome of a hearing. So it is not useful for you to start your deliberations with, well, I kind of had an idea which way I was gonna lean before I ever got here. Those are not okay words to use. It is not okay to have been posting on social media any opinions about development even in general, because you will create a paper trail of your opinions regarding development specifically that can be used against you.
Mhm.
And I'll tell you exactly what that looks like. If developers, and they have done this, cobble those statements together, they will come in here as an applicant and they will say, I'm going to respectfully request that Mr. Hastings recuse himself from these proceedings. And here's the evidence that I have that he is completely unable to be an unbiased decision maker for me. And that is a very uncomfortable seat to be in.
Shame on you.
I'm sorry.
When we have bodies of individuals who develop an opinion, and it doesn't usually happen at planning and zoning, it will happen more often at the council level. If you have a council that is very vocal about, for instance, anti-growth, and all of their deliberations are revolving around anti-growth, and all of their statements from the dais and all of their questions of staff create a theme, then developers start coming in and saying, I demand pursuant to statute, an independent hearing examiner, because here's all the evidence that I have that I cannot get an unbiased hearing in front of this body. And that has happened and is happening right now. So this idea of bias, though this decision came out in 2004, has really ramped up, and the accusations of bias have ramped up in the face of social media. And I've said it like 3 or 4 times. Social media is a dangerous place for electeds and appointeds to be existing.
Really?
So back to that question about bias and if a,
That's where the evidence gets used. Those are
Yeah.
the snippets that'll get grabbed.
Yeah, but.
is it just the developer that can say that, or can a citizen?
An affected party would have standing to use that argument.
Okay, so as an affected party, does that mean within the 300 feet? But what if it's a, a project that would affect the city in itself, something general, or I don't know? If they're,
They have to meet the definition of an affected party.
okay,
And the 300 feet isn't the only, that's just the cleanest one I can
Yeah.
give you for an example.
okay.
But they'd have to meet the legal definition of an affected party.
Say if I were a pickleball player, or I'm sorry, a basketball player, and the parties on decision-making boards were clearly against, a basketball facility. But so if it came to, say, that board, and the developer doesn't bring that up, and I'm sitting there and a citizen, wait a minute, I've heard these people talk against this for months and months, could I request, hey, I don't think they could make a good decision because I'm a basketball
That
player.
example is bordering on a legislative decision, not a quasi judicial.
Okay.
there's a line. I mean, yes, you want unbiased decision
Right.
makers in both, but there's a different analysis that would be done to determine who's being affected by the bias. If that makes sense.
Yep.
And a last bullet point, biased decision makers should be barred from participating in land use applications to protect the process, and I've kind of walked you through a couple of examples of how that happens. So next is ex parte, and I'm almost done, I promise, like, this is it. Ex parte communication. So a quasi judicial officer, that's you, have to confine yourself, to the decision on the record, which we've talked about, that was produced at the public hearing. You can't have any ex parte communication with each other or the public about it or the applicant. And if you do, it can, that's why it says may prevent your continued participation in the hearing. And it may improperly influence you as a decision maker. And it says may because we'll walk through that exercise of determining whether or not that ex parte contact affects your ability to be neutral and unbiased. And last but not least, questions. You've kind of asked them along the way, which I think is amazing, and I love interactive training. Any other? Yes.
Hypothetically, we're in a hearing and Amelia thinks that I'm gonna be a biased commissioner on a topic. She knows how I'm gonna vote and she's like, Mose can't make this decision. Can she somehow petition that I am not able
I
to
would
vote?
suggest if that happens to any of you, you ask your chairman to take a brief break and you come talk to me about it.
Before making it a public issue.
Yes.
Okay. Good idea.
So the ex parte part, there's always issue, well, I anticipate a lot of these coming up, especially with height limitations and code changes and whatnot, and people coming to you at,
Those are
after
legislative.
dinner.
That's fine. You can
Okay.
talk to people about that.
Okay,
Those are legislative.
okay,
They don't have the, when the city is initiating, because that's the city initiating code change, the city is initiating your comprehensive planning process. When we're initiating, like, I hate to draw that just as the distinction, but those are legislative decisions. You can talk to people about those.
okay.
It's these quasi judicial hearings that's really important to protect the due process rights of the applicant.
And where that will come up is, say you go to a site visit and the property owner is there and they want to talk to you about the project. You have to say, if you want to talk, please come to the hearing. I can't talk to you before that. Or you're in the grocery store. And Amelia, you're on the Planning and Zoning Commission. You have this case that's coming up. I want to talk to you about it.
La, la, la.
And there's a reason
away.
that you guys don't know what's coming.
Right.
Until it's on your calendar and you get your staff review, because we're trying to protect you. So if people start talking to you also about a project that you're like, this isn't sounding familiar at all, you need to say, is this a pending application? Are you filing an application with the city? Yes, I am. Then I really, with all due respect, I can't talk to you about this. It's hard. It can be a lonely, quiet life. Point to the official. Thank you.
Thanks,
you.
Linda.
Especially with social media, really. quiet
Oh,
now.
I should stay off of that.
Oh, that's the. Let's see. Oh, yes. Any other questions? And I should just ask before we move on to our next item. We're all good. Okay, so we're looking at item 6B now. Review possible action on Planning and Zoning Commission bylaws, and I will yield the floor to City Planner Amy Tweeten for an introduction of this agenda item.
So as we discussed, the bylaws we have had some old language. And looking into it, what we discovered was there had been official changes through resolution at city council, like to change the meeting date to the first and third Tuesday. And also to provide a stipend for commissioners per meeting, but those never made it into your bylaws. So the majority of the changes to these bylaws are just those cleanup items. So, um, but there's a couple that I wanted to just bring up for possible discussion, whether the commission feels strongly we keep them the way they are. If you want to talk about making changes or recommending changes to city council. And one of those is that we have a term limit of 2 full terms. In the past, that hasn't been followed clearly, and I haven't found, because I thought, well, these other things that aren't in the bylaws were actions by council, but I didn't find that. So, again, term limits serve their purpose. Planning and zoning is a commission where you have to do a lot of homework. There's a lot of learning of what are the processes, procedures, following code, following the standards. And, you know, so it could be having someone with longer longevity on the commission is a helpful situation. So I just highlighted this in case the commission wants to discuss whether we keep the current 2-year. So it may be you're filling out, sometimes people are appointed to fill out someone else's term. You can do that and then have 2 full terms under the current restriction. But I just wanted to kind of bring that to you and see what the commission's feeling was.
First question, is this our decision to make or a recommendation to anybody else?
You would, if you were to suggest a change or want to change, it ultimately has to be approved by city
Then
council.
it would go to council.
But these are your bylaws of how your meetings are run, how your board is. I mean, the city code determines your term, how many commissioners. But the code doesn't say you're limited to 2 full terms. That's
Gotcha.
strictly in your bylaws.
Gotcha. Commissioners, go ahead.
To your point of experience, personally, I felt like every year I'm here, I definitely get a little more educated, and you know, the experience does help as far as how comfortable I feel about, you know, my role. 6 years is a considerable amount of time. But I know as far as our chairman position has gone, it's almost always been whoever's been here the longest is usually the most, you know, it's the first choice of who's going to be the chairman, at least for, except maybe one person for a short time. I don't know how that would play into it though. Cause I think when I first got here, our chairman had been here for at least 2 terms or more.
There was a couple people on it when I joined it. I think the number they threw out was they'd been here 9 years. I don't know the details on that, but I certainly agree. Like what Melissa was saying is that the longer you're here, the better you get at it. On the other hand, there's people who want to be on it, right? I mean, there's like,
Sometimes, yeah.
there's usually like, there's people who.
Stinks after 3 days, guests stink after a week, and commissioners stink after 6 years.
Yeah.
I can see why. I mean, at a certain point, being on some boards that I've been on and actually being chairman of some boards, it is innate in human nature at a certain point to you to believe that you know better than anybody else. And when that starts happening, the effectiveness of the commission starts failing.
Hmm.
And so I don't see
Good point.
6 years is plenty enough time to make your stamp on city of Sandpoint.
I'm comfortable either ways. I can.
As
see-
am I.
I
Me
can
too.
see the 3-year, going to 3 years or 3 terms.
So nine, but
Nine,
no more.
I could
Yeah,
see that just
90
because-
is all.
Maybe 9 max if you've
Yeah.
finished a term. If you come in the middle of a term and you've done like a year or something. So like no more than 8 or something like that, or I don't know.
Well, or leaving it the way it is, which would still accommodate for that.
Yeah.
Because that means if you were appointed, that didn't, to fill somebody else's term, that doesn't count. You
Yeah.
can still have 2 more. So you could be here 8 years or whatever, but
I mean, depending on when you came into somebody else's term, you could be almost 2.5 or more
Yeah.
years anyway, extra.
Amy, does it speak to whether or not they can have a year or two off and then be appointed again? Because we should probably address
Doesn't
that as
say.
well.
Yeah, I was thinking of that too. I mean, that would be,
That was gonna be
So
my question.
they fill out their term, they
You have the
expire,
term off.
they term off.
How long before you
and
can
then
come back?
Years, they apply again
If you
to
want.
get back on.
Yeah, that was my question was whether or not the current bylaws speak to whether it's, once they've termed out, they're done for life.
Yeah,
Or they could take so much of a hiatus and then reapply again, because we should probably address that.
yeah.
So in other
right
words,
And the
now-
current
Like
bylaws
that.
don't.
Yeah.
Right? Right,
Right.
yeah.
what if
Because
it-
there is a former commissioner
But
that
I
has told me.
The fact that it says
That-
they'll serve more than
Sandpoint,
two
yeah.
full consecutive terms kind of
opens
makes
the
me
door.
think that if you could have a term, have a gap, have another term.
Right.
It does imply that.
Yeah.
Yeah.
It doesn't explicitly state it, but it does imply that.
I'd say, or
Let's
you've lived
stay
in
with the way
Sandpoint
it
for a
is.
long time and you've gone through a couple different phases in your life and you could sit on planning and zoning a couple times.
I guess my,
Or we can be like the Supreme Court and have lifetime terms.
No reappointments.
With the lifetime paycheck that comes with
there
it.
you go, that's right.
I think my opinion is that at times there's been considerable turnover and just well,
Mhm.
not a short time I've been here, but not a long time either. There's at times we've had people who only were here for like 1 or 2 meetings and then they're gone for whatever reason. Not to say like we can't get by with that, but I think having like a quorum, like 3 or 4 of us that have been here for a while kind of helps the newer people to catch on and get their feet, under them while the meeting's still effective, or the commission is still able to, conduct a hearing. Although, like somebody else said, the 6 years is a considerable time too. I mean, although there is options for people above us to remove us, right? Like, we can, if we're bad, we can get taken out, right?
Yes.
Or if we don't show up enough, is that in here too? Like,
Yes.
The only thing, were you?
Yeah,
finished?
go ahead.
The only thing I was thinking about it was, for most of the planning and zoning stuff that we do, this is more than enough time, personally, I think. The only other side of that was shepherding us through this, the comprehensive plan. High turnover during a comprehensive plan has been difficult, just because you have to go back. You're like starting over every time there's a large number of new commissioners, because they weren't there when all this stuff was talked about before and even maybe decided on before, sort of stuff. But for the vast majority of the time, I think the way it is fine and dandy.
Okay.
That's just
We'll
one person's
just,
opinion.
Well-
keep it the way it is.
I mean, after each term, you gotta get reappointed anyway, so you may not be here.
True, yeah.
May not be
that's right.
reappointed.
Yeah, it's not an automatic
Mhm.
renewal. Yeah.
Okay, so then all this language is existing.
So
I'd
just
add,
to be clear, we're okay with non-consent, so 2 terms,
Correct.
but then you can come back. That's effectively what we're saying.
I think that's the
Yeah.
loophole in there. Yeah.
Loophole, I don't know, I mean, I'm not sure it's the end of the world, but.
No, I
Yeah.
mean, how many times is that gonna get brought up?
Yeah.
It's not,
Yeah, fair.
and nobody has to be appointed for.
okay, so we're keeping it the
Keep
way
it,
it
keep
is.
it.
Okay, all right. I just added for the, it had stated that you are not paid at all, and I had just put in that based on the city's budget, you may be, get a per diem. This was, I added this just because a lot of bylaws, it's very common
Mm.
to let boards know what is conflict of interest and that you know, in a small town, just because you know someone, you don't have a true, you know, don't recuse yourself because you don't have a true conflict of interest. So this is just kind of spelling out what really is a conflict of interest.
Excuse me.
Bless you.
What's the definition of direct interest?
That financial usually?
Yes.
Direct financial benefit?
Yes.
So financial, that's the,
Well, it's you get
what is
financial,
that?
you have a interest in what the outcome is. So, your neighbor is asking for a variance for a height variance, for example.
No, I'm thinking more like the office building next to ours wants to do something which is pissing off my boss, who's the owner of our building,
I don't think.
who's
that's
my
a-
employer.
Is it cutting your pay because of it?
Not because of it, but he's got direct access to me.
We'd probably talk about
All right.
whether or not you can be objective and neutral.
Gotcha.
So again, it's if you feel you have if you have a conflict or you're an affected party, bring it to the attention of the body. And if you feel that, or to legal counsel to confirm whether or not you can be, whether you have a conflict or whether you can be, neutral, unbiased in participating. So that's all, that's just all, the yellow is new. And I just highlighted the term limit just to see where if the commission had any feelings, so that would remain the same. Other than that, essentially the bylaws have now incorporated changes that have been done through resolutions of city council, so unless there's one floating out there that I have not found, I think this would reflect changes that have been made since your 2001, I think was the last bylaws. Let's see here, I have, yeah, here's your current ones were adopted.
Mr. Chair,
2001.
Yes,
I do have
Mr.
just
Renner.
one question
Yep,
on quorum. Now, can we be on Zoom to formalize a quorum? If there's 3 people here and 1 on Zoom?
Yes.
Okay,
Yes.
just,
And this question also comes up. If you only have 4 for a meeting and 1 has to recuse themselves, do you still maintain a quorum for the decision? And the answer is yes. Quorum is established at the beginning of the meeting, irrespective of whether or not someone has to recuse themselves for a particular decision.
Hmm. Hmm.
It stinks because then you leave 3 commissioners making the decision,
I thought
but
that would've
it
gone out.
happens.
you could they decide to table at that point?
They could,
And-
they
and
can
till-
make whatever decision, yes.
So let's say there's a quorum of 4 and there's a vote that's 2-2. Is it, it doesn't pass.
It doesn't pass.
Yes.
I didn't notice, did it say in there is the number 7 in print, or that's tradition?
I think that's code.
7's in code.
Code.
It
It's
is.
in your code.
Mhm.
Okay.
This is that new language here for compensation and political affiliation. Members shall be paid per diem for each meeting attended as determined annually through the city budget process. So if 1 year they take it out of the budget, then you don't get it.
For $30.
That's when there's a higher turnover.
Yeah.
Statement in there about cost of living adjustments or anything?
Yeah,
Yeah.
COLA? We need a COLA. Hour is what you can pay.
Does it say when,
New bike tires.
when it was one meeting a month, when this was done?
No, it said you will not be paid at all.
Hmm.
Is what the current bylaws say. So here's the
Yeah, it said without compensation.
In two
without
thousand one.
compensation, correct?
Is a stipend or per diem technically compensation?
That's
I
why.
don't
they're
even know if
changing
it's,
it.
you could call it per diem. It's really more of a stipend. It's a meeting stipend.
It's like reimbursement of expenses or something like that. It's not necessarily, well, it's not payroll. So,
I can't use it to bump up my Percy.
Yeah,
That's
but
all.
you get taxed.
You could,
You gotta report that to the IRS if it's $600 more a year.
well, I was maybe,
Had to deal with that.
you could do like the
Oh.
county, though it is per diem. And I was getting paid 35 cents a meeting because I could walk to the courthouse.
Nah.
Big time. Check it was
There you
written.
go.
Yeah, 35 cents a meeting.
Looks good. Thank you, Amy.
All right. Do commissioners have any further questions for staff at this time? Thank you all very much for your lovely presentations.
Do you want to recommend these, these draft bylaws as presented to city council?
You need a motion for that?
You would take an action.
Yeah.
You would take a motion, you would vote.
I would move to send these to the city council for approval.
A second.
All in favor, any discussion? All in favor, say aye.
Aye.
Any opposed? Motion passes. Anybody in the public out there have comments?
Yes,
On my
we do have one
script.
individual on Zoom.
We have one person on Zoom. Would they like to make a comment?
If you're on Zoom and you'd like to talk during public comment, please raise your hand at this time.
Are we still on?
There is no one on Zoom that would like to speak during public comment.
Thank you. All right. Well, with no further business before the commission, this meeting is now adjourned at 8:02 PM.
Good job.
We just need to know when the going away party is.
When is your last day?